Legal defenses in a criminal trial serve to challenge or negate the prosecutor's evidence and arguments, aiming to establish the defendant's innocence or reduce their culpability. Here are some common types of legal defenses. 1. Alibi. This defense asserts that the defendant was elsewhere at the time the crime was committed and could not have been involved. 2. Self-defense. The defendant argues that they acted to protect themselves or others from imminent harm. This defense typically requires the defendant to demonstrate that the force used was reasonable and necessary under the circumstances. 3. Defense of others. Similar to self-defense, this defense asserts that the defendant acted to protect another person from harm. 4. Defense of property. In some jurisdictions, individuals may be allowed to use reasonable force to protect their property from theft or damage. 5. Duress or coercion. The defendant claims that they were compelled to commit the crime under threat of harm or injury to themselves or others. 6. Entrapment. This defense argues that the defendant was induced by law enforcement to commit the crime they would not have otherwise committed. 7. Insanity or mental incapacity. The defendant asserts that they were not mentally competent at the time of the crime, therefore lacking the necessary intent to commit the offense. 8. Intoxication. Depending on the jurisdiction and the circumstances, voluntary intoxication may or may not be a valid defense. In some cases, it can negate the intent required for certain crimes. 9. Mistake of fact. The defendant claims that they were mistaken about a key fact relevant to the crime, which negates the mental state required for the offense. 10. Necessity. This defense argues that the defendant committed the crime to prevent a greater harm or evil. 11. Statute of limitations. If the prosecution fails to bring charges within the prescribed time frame, the defendant may raise the statute of limitations as a defense. 12. Consent. In certain cases, such as assault or battery, the defense may argue that the alleged victim consented to the actions in question. It's important to note that the availability and viability of these defenses can vary based on factors such as jurisdiction, the specific elements of the crime charged, and the evidence presented during trial.